This is the MonDak OilField Review with host Jason Spees.
My name is Jason Spees, and this is the MonDak OilField Review, heard on the Crude Life Media Network. On today's episode, we talk with Josh Swanson with Vogel Law Firm. Swanson gives an update on the ongoing battle with the state of North Dakota and several North Dakota mineral rights owners in a bizarre case that just doesn't seem to go away. In just a moment, part of our exclusive interview with Josh Swanson with Vogel Law Firm, right here on the MonDak OilField Review. It seems everywhere I go these days, someone is telling me about the success of Hatch coaching. Listen to what professional speaker Mark J. Lindquist has to say.
He is a person in this market and now in markets across the country with Hatch coaching that is revolutionizing the way people approach the business. He's reinventing the way people look at the people model. That's why he brings in hundreds of people from all over the country who are trying to figure out how to do what he's doing in their market.
For more information, call 701-212-1572 or visit coachingwithhatch.com. That's coachingwithhatch.com. Welcome back to the MonDak OilField Review. My name is Jason Spees. Up next, Josh Swanson with Vogel Law Firm.
There is nothing about the REAP decision that required the Industrial Commission to adopt the Lincoln Associates line or had anything to do with the legislation. The Bartlett and West study was done 5 years before the decision in the REAP case was issued in 2013, and that dealt with an entirely different subject, the shore zone, which is the area between the ordinary high water mark and the ordinary low water mark. And so the NDIC is trying to muddy the waters, so to speak, by trying to interject the REAP decision into it. The only case that is relevant to what they did is the Wilkinson case, and the court case is cited in that decision that says if the state claims these minerals, that is an unconstitutional taking. The state cannot go back and take minerals that have been owned by private. This is the key, Jason. This is the key. What the state is doing with these 10,000 acres that they're now claiming that they've never had a right to, they are going back more than 60 years and telling these mineral owners that we don't care that you reserve these minerals when the United States acquired your property for Lake Sakakawea. We do not care that you've been leasing these minerals for the last 60 years. We do not care that the state never had a claim to these in the last 60 years. And we don't give a flip that the United States Army Corps of Engineers determined that this is where the ordinary high water mark line was. The state threw all that out, and they're relying on a survey done by an out-of-state firm to say where the historic Missouri River line is some 60 years ago in present day, which is utterly absurd, and it's opened the door for more lawsuits, for constitutional challenge, and the certainty that they purported to be pushing for going back to the last session is totally out the door.
To listen to the full-length interview with Josh Swanson from Vogel Law Firm or to listen to other MonDak OilField reviews, visit thecrudelife.com. That's thecrudelife.com. The MonDak OilField Review is part of the Crude Life Media Network. Check us out on Facebook and Twitter. All of our social media links are available at thecrudelife.com. From the staff of the MonDak OilField Review, my name is Jason Spees, asking you to keep calm and frack on.